Okay, here we go. We'll be accepting questions this morning. Just some housekeeping. You can submit your questions via the GoTo webinar console. Let me just pull that up for you. Essentially, you can submit your questions here. If you click into the section relating to questions, put any of the questions in there. We'll be reviewing those questions during the procedures this morning, and then we'll hopefully review those and come back with any questions you may have. The more questions you ask, the better. Okay, we just forwarded the slide there. Just to give you the instructions. So, your presenters this morning are my good self, Derek McGivney, Managing Director of Cordium Asia, Winnie Lee, one of our senior consultants, and joining us from San Francisco is Alexandra Folk, a Vice President in our U.S. consulting team. Prior to joining Cordium in March 2016, Alexandra held legal and compliance positions at a variety of U.S.-based investment advisors and was a Vice President of Bank of America Merrill Lynch in New York. Winnie Lee has been with the firm since Cordium arrived in Asia in 2013, having worked in the financial services industry in Hong Kong for 16 years, having various positions including managing risk, compliance in a bank, working with the MPFA, and more recently as a consultant. I have been working in governance, risk, and compliance for 19 years, 11 of them at Cordium, 3 in Hong Kong, 1 in New York, and 6 in London. We all hopefully provide different perspectives to this topic and are prepared to answer any questions you may have. So moving on to our agenda this morning. We're going to be talking about some of the basics just to remind people of what we're doing here. We're going to go through some of the key requirements and considerations as they're listed there. I'll come back to them in a second. The idea really there is to go through the basic stuff, provide people a little bit of a reminder of what they need to do for their annual updates, and basically elicit any questions that potentially you may have. I hope to run through that in about 20 minutes, hopefully not staying on one topic for too long, because most of this should be just a reminder. We'll then move on to ask Alex to provide us a regulatory update in relation to SEC Exempt Reporting Advisor issues and general issues relating to U.S. compliance. Okay. There'll be some question and answers at that stage, and then if we do have time, we'll just run through some of the services we're providing here in Asia. So, starting off with the basics, Exempt Reporting Advisor, what it means for the firm. The Dodd-Frank Act changed the U.S. Investment Advisors Act of 1940 and required many investment advisors to register with the U.S. Securities and Exchanges Commission at that time. It created a new class of investment advisors generally referred to as Exempt Reporting Advisor. ERAs are advisors that rely on either the venture capital fund advisor exemption or the private fund advisor exemption. Generally, we see firms that are relying on the private fund advisor exemption. Firms in Asia usually do not advise any U.S. managed accounts and manage less than 150 million in regulatory assets from a place of business in the U.S. Usually this is because a lot of the firms here don't have a place of business in the U.S., so therefore the 150 million number is a bit of a red herring. We understand there are 120 exempt reporting advisors located in Hong Kong. So, the areas that we're going to go through now is, well, exempt reporting advisors are not required to register with the SEC. They are still subject to certain obligations, which we will discuss today, including the following. Practical issues with accessing the reporting portal and what you need to report. Key policy expectations of exempt reporting advisors. We'll discuss pay-to-play briefly because it was a topic of interest in the last year, but only applies really to U.S. nationals. The anti-fraud provisions, which is how the SEC applies most of the rules to exempt reporting advisors. We'll talk some around US insider trading, some points on record keeping, and also potential US reporting requirements that apply to Hong Kong firms. So, ERAs are required to complete a truncated version of the form ADV. It's completed online through the IA or D system. The information that you provide is publicly available. The first part, identifying information, requires you to provide name, address, principal office, record keeping address, contact, registration, AUM size, and if you have it, your LEI number. Part 2 refers to your type of registration as an exempt reporting advisor, as in whether you're venture capital or private fund advisor at the time. Part 3 is, are you a company or other type of organization, if possible, and Part 6 is whether you have other business activities and whether you're registered. For example, are you a CPO? Are you a CTA? Do you undertake any other regulated activities on a global basis? Part 7 talks about your affiliations, financial industry affiliations in particular, and any connections to any private funds that you're offering. Part 10, control persons. So this is referring to people who are in essentially running the business or controlling the business. There's also supplemental information to be provided in Schedule A in relation to direct owners and executive officers. Part 11 are your regulatory disclosures and issues relating to any sort of disciplinary issues that you need to report to the SEC. This also has an effect on your bad actor notifications. And we also just highlight that for a lot of our firms, they're obviously answering questions from an SFC perspective of the questions that they filled in their Form A. If there's any updates, they would be expected to update the SFC. But there also need to be a consideration of whether you need to update the SEC in relation to their disclosure information. The questions are similar, but there are slight differences, so it pays to pay attention to those differences. We also have Schedule B, talking about indirect owners, Schedule C, which is used to highlight changes in Schedule A or B, and D is supplementary information around the funds and the structures. Quite interesting there. One of the reasons why we brought up deciding to do this webinar was because of the recent memorandum of understanding between the cooperation between the SFC and the SEC regarding cross-border regulated entities. And one of the areas that we think that this might come up is in circumstances where, for example, the SFC and the SEC collude to confirm whether the information that they're receiving is consistent. So one of those areas in particular might be around control persons, structures of firms, substantial shareholders. There are differences, but it's always worth considering when you're updating one whether you need to update the other. So, the ADV needs to be updated as follows: at least annually or within 90 days of the year end of the advisor, or more frequently for material developments. Prompt updates to information in items 1, 3, and 11, so basic details, form of organization, or disclosure issues. I just thought it might be worth just bringing Alex in here to sort of explain what they mean by talking about prompt updates.
Yeah, sure. Hi, everybody. It's good to be talking to you today about SEC compliance, particularly as it applies to ERAs. So when the SEC is talking about prompt, they haven't given us a specific definition about what prompt is, but at Cordian we take it to mean within 10 business days. And so far we haven't had an issue from the SEC with complying with those 10 business days.
Okay, and what are the consequences of being outside those 10 business days? Where does it cause an issue, or where can it cause an issue?
I think it can cause an issue, and again, this hasn't been specifically defined by the SEC, but I think it can cause an issue when something that is a material piece of information, and particularly in items 1, 3, and 11, And the materially inaccurate information in item 10, if that goes on for too long, the SEC can claim that you've represented on your annual form, which is what the ADV is. It's your annual piece of communication with the SEC, that you've misrepresented a certain fact about your business. And so that can be an issue. That being said, I think that when those mistakes are made unintentionally, the SEC, and then later fixed, and they can be fixed, by the way, at any time. You can sign on to IARD and update your ADV. The SEC has not come back and penalized firms for fixing it at a later date. But you should be updating that ADV as soon as possible, and certainly within the 10 days if you can.
So the message there, to a certain extent, is making sure that we're, making those. If you identify an issue, that you make the correction as soon as possible. And generally, there hasn't been too much issue with that from the SEC's perspective.
I think that's a fair characterization.
Okay. So then moving on to some of the more practical issues that we tend to hear about when we're speaking to firms the minute they start worrying about their registration. In a lot of cases, maybe the initial registration has been done by someone else, or there might be a change to individuals. Updates are generally made on the IRD system, the Investment Advisor Registry Depository. You can look up all the information on your firms, or in fact other firms, on what they've put on there by looking that up on the SEC website. But essentially, just some of the basics again. You must request access to the system through a process called entitlement. Once entitled, you can pay the required fees for registration, which are not that significant. At the very beginning of the process, you would have submitted a paper form called the New Organization SAA Entitlement Form. And it doesn't make you a superhero, but it makes you a super account administrator. This form can be scanned and sent in to obtain access to an ID and password for the IRD. Forgotten ID passwords can usually be refreshed online, but if, for example, it needs to be a new user, you might need to have an individual to require an authorized signatory within the firm to call the hotline. Normally, when you're requesting the information on the passwords, you're providing the password for someone who will have an access to update the system, but it will be signed off by, for example, a responsible officer or senior manager within the firm, and therefore, if there's been any change to the contact details, those persons can pick up the phone to the SEC and make the changes or request that those changes are made. Usually, the system is only available from 5 a.m. to 11 p.m. Eastern Time. So I think that converts to basically not being available in a lot of the time zone in Hong Kong. Alex, I just ask additionally, do you see any other practical issues with the Form ADV access, logging in, or just having general access to those system problems?
So I think you're right to point out that there is a time that the IARD system is open and when it's closed. If you do have any trouble accessing it, I think what you described about the super account administrator, that can sometimes be an issue. If someone leaves the firm who was the former super account administrator and you need to set up a new one, typically calling IARD, and that's a separate group than the SEC, by the way, so some people don't want to call the SEC because they're afraid that there might be some red flags raised or some repercussions. But the IARD system is run by FINRA, which is the SRO for broker-dealers, and FINRA has a different phone number that you can call and actually access someone to talk about technical issues. So if anybody does come up with any kind of problem that is unique to their organization or to their staffing and needs to sort something out, I think that help number that you can retrieve from the IARD website is the first place to go.
Okay. Thanks for that. So moving on from some of those practical issues, and if anyone does have any practical questions in relation to use of those systems, please do request ask a question. The questions will, we're not reading out the people who's asking the names of the people who are asking those questions, and if we can't answer those questions, we'll get back to you after the webinar, because we will have access to the contact details as a result of the questions coming in. So now moving on to more of the the sort of regulatory issues that affect firms that are exempt reporting advisors. So, first of all, pay-to-pay political contributions. As I said, this was a particular hot point last year as a result of the U.S. elections. It is something that was discussed heavily by, by our compatriots and by our friends in the U.S. But in a lot of cases, when we're talking about this to Hong Kong firms, it doesn't potentially apply at all, because it turns out that foreign nationals, from a U.S. perspective, which includes corporations, partnerships, and individuals who satisfy the definition, are prohibited from making any contributions, paying anything in connection with any U.S., state, or local election, directly or indirectly under the federal election campaign. So that refers to the ability to be able to pay to these campaigns. And then against the pay-to-pay rule, which is section 206.4.5, that is designed to curtail the influence of pay-to-play practices by investment advisors with respect to government entities, including all U.S. state and local governments, their agencies and instrumentalities, and all public pension plans and other collective governance funds. So therefore, it should only generally be relevant to U.S. nationals who are able to make the donations. But then, if they do make the donations, there are certain restrictions. And those restrictions can be potentially quite wide, including situations where, for example, you might be working with a school or a university that is deemed to be, for example, an instrumentality of a U.S. Local government. So there is some issues to be concerned on if you are, in fact, a U.S. national and therefore allowed to provide the contributions. And then when you do provide the contributions, under the pay-to-play, covered associates are prohibited from making those donations to government entities with severe penalties for violations. There are certain de minimis exemptions which exist. These are quite small. I think it's less than $350 in total. You cannot circumvent the rule by directing or funding contributions to third parties. And there are severe consequences for violations as discussed, including potential 2-year timeout from receiving fees if it is found that a U.S. national within your organization who is a covered associate, as defined here, has provided a contribution to a political campaign in relation to an individual who has control essentially over the appointment of investment advisors to their pension funds, management structures, to their endowments, to their various structures there. In particular, the covered associate includes general partners, managing members, executive officers, or other individuals with similar status or function. Any employee solicits a government entity, and any person who supervises directly or indirectly, and any of the political action committees. So that's just a quick sort of overview of anti-fraud provisions if they apply to you. Moving now on to one of the big areas that affect the exempt reporting advisor. The anti-fraud provisions, essentially, Section 206 of the Advisor Acts, prohibits misstatements and misleading omissions of material facts and other fraudulent acts and practices in connection with the conduct of an investment advisory business. What's quite interesting here was in relation to when the requirements for registration came about, one of the issues was registration is required. The detailed rules and regulations of the SEC under the registered investment, or to become a registered investment advisor, do not apply to an exempt reporting advisor. However, Section 206 is quite a widely interpreted provision in relation to the requirements on fiduciary responsibilities of investment advisors. And this means, and this is how they would apply most of the requirements and most of the violations to people who are registered and acting towards U.S. investors. The the Act applies to, or sorry, the section applies to all investment advisors whether they're registered or not. And basically it requires investment advisors to be treated as fiduciaries to their advisory clients. One thing I always bring up when we're talking about U.S. regulations is it's the Investment Advisors Act. And one of the ideas there is, in a lot of cases, say for example in the UK and in Hong Kong, we have asset management as the activity, whereas in the US the SEC regulates investment advisory activities. So sometimes it can be confusing when you're referring to advisory clients in this case, but from an SEC perspective, the advisory clients includes investment advice, but also in particular discretionary investment management. Basically, the rule says that there's a fundamental obligation to act in the best interests of clients and provide investment advice in the client's best interest. And this also applies through to other regulators. And as we know, the SFC has specific requirements on conflict of interest and general fiduciary duties. And in particular, they're talking a lot about this duty for investment managers and the operators of those funds as it would apply in relation to the new Fund Manager Code of Conduct in Hong Kong. Generally, there is a need to prevent advisors from taking unfair advantage of a client's trust. And in effect, this is how a lot of the US laws are applied to exempt reporting advisors. An ERA owes a duty of undivided loyalty and utmost good faith. It overlaps with the requirements as we talked about. The practical implications are they must employ reasonable care to avoid misleading clients, must provide full and fair disclosure, must eliminate or at least disclose all conflict of interest that might lead to rendering advice that is not disinterested, e.g. allocations, expenses, etc. Cannot use client assets for own benefit or the benefit of other clients without consent. Generally, this can, as I said, be a widely interpreted requirement. The US, from a legal perspective, generally allows firms to manage these requirements by ensuring that they have appropriate disclosures when they are dealing with clients, to say that if there's any question of conflict, if the firm is able to disclose to the client that they're doing something which may be provide some discretion in relation to how the client would ultimately be treated, that the disclosure in a lot of cases can cure the issues that might come up. Is that a fair assessment, Alex?
Yeah, I think that's fair, Derek.
Yeah. You know, there are one of the areas that we always come up in relation to anti-fraud provision is when we look at things around, for example, there are no detailed requirements from a marketing perspective that apply to an exempt reporting advisor. But when we're talking to a lot of clients more recently, we've been saying, well, look, you would be caught by the anti-fraud provisions, but we would recommend that you have a look at the more detailed provisions that are being provided to the registered investment advisors, because the detailed provisions in relation to the registered investment advisors are standards which you would be your investors may be expecting you to adhere to, because they're looking at your presentations versus presentations coming from firms that do apply the full registration requirements, and therefore the sort of the peer group that you're being judged against will have more detailed and more extensive disclosures, and this can help you in terms of demonstrating to your investors that you are providing the appropriate level of disclosures. Just moving on to some specific examples that they highlight in relation to anti-fraud provisions. Section 206(3) requires, where you're acting as principal for your own account, which is generally not an issue for a lot of our clients, or in relation to agency cross transactions, again, generally not something that comes up to our clients, but is highlighted as a specific area of relevance. So, the next section of interest that we find a lot is the prevention of insider trading. ERAs must implement written policies and procedures reasonably designed to prevent the misuse of material non-public information. Generally, we would hope that most of our SFC registered firms already have those policies and procedures. It's also worth considering making sure that if the jurisdictional issues, which I'll come to in a second. But in the US, the general definition is that illegal insider trading is generally understood to include trading by an insider while in possession of material non-public information, which we'll explain in a second, or trading by a non-insider while in possession of that information, where the information was either disclosed to them in violation of an insider's duty to keep it confidential or was misappropriated. And then the concept of tipping relating to communicating MMPI to others. We generally highlight to firms and their employees not to get bogged down too much in the complex legal definitions, as you may be vindicated after a long regulatory investigation, but your reputation could be tarnished forever. And we've certainly seen circumstances along those lines in the last couple of years, in particular a recent example where there's some allegations been made in which the SEC is doing some significant investigation, and they're looking to find, they're looking to find individuals. Once that newspaper article comes out, it becomes very difficult to address. So therefore, this area is of high importance for firms to have appropriate controls and processes in place for, and that goes for every jurisdiction. I'm just going to move on to well, where's my slides? Some of the definitional issues. We'll talk about the jurisdiction. I might then revert back to Alex for some comment. So, what is material or MNPI from an SEC perspective? So, information is material if there's a substantial likelihood that the disclosure of such information would have been viewed by reasonable investors having significantly altered the total mix of information made available. The examples provided here are pretty similar to the examples provided by the SFC in their notes relating to insider information. There might be some slight differences in interpretation, and this is dependent on precedents and legal issues, but it's worth essentially grasping the idea that the prevention of insider trading is of an interest to both the SEC and the SFC. It doesn't matter whether or not you use the information under the US requirements, because if you are in possession of the information in the company, it may be imputed to everyone else there, and if the firm trades, potentially you've committed insider trading in those circumstances. When we're talking to firms relating to jurisdiction, we try and highlight this issue. Trading on US markets or using US market infrastructure to trade will be part of the jurisdictional issue. Countries or regulators care about their own market integrity. So the US cares about its market and is monitoring its market and what people are doing on that market. The Hong Kong cares about the people that it licenses. And if they get into an issue with an overseas regulator in relation to their trading, the overseas regulator could take action from a point of view of their market integrity, and the local regulator could take action from the point of view of their licensing system. So it's always worth keeping in mind that when you're doing your assessment of your market manipulation or insider trading risk, you're identifying the risks and the regulators that you may need to consider you need to satisfy to be able to demonstrate that the firm has appropriate controls and processes, because there are a lot of circumstances out there in the market where it's not the firm that's done the undertaken the market abuse or the manipulation. It's an individual outside who's working for the firm but is acting outside their policies and procedures. The better your policies and procedures and processes to prevent this, the more likely you're able to escape specific fines in relation to your activities. We are, and obviously with the memorandum of understanding, we are seeing regulators speak to each other more frequently on such issues. So we generally think that general care is required around this area. Would you agree with that, Alex?
Yeah, so definitely the communication seems to be increasing, not decreasing, between the regulators. And I'll also say that just to point out, and I don't think this is going to be news to anyone, but insider trading is a very hot topic for the SEC. And if they do find any evidence of it, they'll most likely move forward with an enforcement case. I think, so then it's very important to take care around insider trading. I think that there's the different elements, who's an insider, what's material, what is non-public information. What I see most firms doing is really focusing down on that non-public aspect of it. And if they have non-public information about a publicly traded company, making sure that that security goes on a restricted list and that all employees understand that that security is restricted. So therefore, the firm doesn't trade in it and get into the type of issue that you've been describing.
Yeah, and I suppose the other point there is training becomes really important, and record keeping as well.
Yeah, absolutely. Everyone should understand what material non-public information is at the firm, understand how to spot information that is non-public, and understand that they should report it to compliance so that that security can be restricted.
Yeah, and we do work with a lot of firms on an international basis. We're not, sometimes it's difficult to get a phone call 5 minutes before the market closes and say, here's the fact pattern, can we trade? It's very difficult for us to make that, help people make that decision, and even a lawyer is not going to make that decision. So the best way to prepare yourself for managing this area is ensure that there's, detailed processes and controls in the firm in relation to managing when these issues come up. I always say, some people, when we're doing a lot of training on market abuse or market manipulation or insider trading, that, some people will never come across an issue. But the issue is that 1 or 2 times that it comes up for and it's relevant to you, you need to know exactly what to do at the time, and you may not have access to, someone who can direct you in relation to what you need to do. So it is a very important area. So just moving on then to some of the more, I'm going to call it more administrative issues, is around record keeping. There is issues relating to market abuse, for example, the segue being, in a lot of cases, one of the defenses that you can bring up is because you've traded in something while you may have been in possession of the inside information within the firm, but you've traded in something because you have demonstrable records to show that that trade was already on the system and that you're actually following a pattern that was appropriate. So there is some availability for defense if you have specific records demonstrating how you've undertaken that action. Again, something to look at in relation to how you manage the risks. But Section 204 of the Act requires advisors to make and keep records, to make and disseminate reports to the SEC as prescribed by the rule. I mean, essentially, the Exempt Reporting Advisor rule covers this. It's an express exemption for advisors under 203, but not for exempt reporting advisors. Therefore, you're subject to the record-keeping requirements. And generally, what happens is, if the regulator asks for information, if you can produce that information as fast as possible and as quickly as possible, you're less likely to, you're able to manage the SEC in terms of making sure that they're comfortable that you have all the appropriate records. The exemption under the Reporting Advisers Act is saying you don't have to provide detailed information to them on a regular basis, because but they still should be able to come back to you and ask for that information in hindsight. So just worth keeping an eye out to make sure that you're satisfying your record-keeping requirements. Generally, if you have SFC record-keeping requirements, there's a similarity. We have done an analysis. There are slight differences in terms of how long you need to keep things, but generally, the information you're required to keep is usually the same. So I'm just going to hand over to Alexandra here to go through the possible U.S. filing obligations, and she'll then take forward the rest of the presentation with regard to providing some updates from the SEC side of things. I'll leave it to you.
Okay, great. Thanks, Derek.
And just sorry, just one other thing. We haven't got any questions yet, so we'd like to, if people would like to ask any specific questions, please do go ahead and ask the questions through the dashboard.
Yes, please ask away. I think it's important to note before we go through the U.S. filing obligations, and these are in addition to the ADV. So the way that I look at, your filing obligations, one of those is the Form ADV. In these forms, the 13 forms that come from the Exchange Act and Reg D form at the bottom there of that list, they're all sort of a part of the whole group of forms that you have to submit. to, or that you may have to submit to the SEC. I think it's important to note before we go through this that under the U.S. regulatory regime, unlike other regulatory regimes, technical reporting requirements like these forms I'm about to go through, like the ADV, are relatively, and not saying they're not important, but relatively less important than the actual compliance program that the firm operates. You know, the reporting obligations I think are comparatively minor, but the SEC has broad authority to check up on its registrant to make sure that they're following the regulatory requirements that they set out. And those are pretty detailed. Derek just spent time going through them, and you can imagine for fully registered advisors that they're even bigger. So, you know, that being said, there still are some actual reporting requirements. Beneficial ownership reporting requirements are required if you hit a 5% trigger of owning 5% of a particular company. And please note that these are securities that you acquire. They don't have to be acquired in just a sale. It can come through other means as well. 13D and the 13G are a little different. 13D is a long-form report, and that's if you expect to exercise control over those securities, or control, I'm sorry, over the company of the issuer. And the 13G, if you expect to maintain a passive investor status, then you can fill out a 13G, which is a little bit shorter. You can see that note underneath the first bullet point that says short form reporting is available to passive overseas firms that are registered under a regime which is deemed equivalent to the SEC's reporting regime, but not to ERAs. Institutional investor reporting on Form 13F, those are for investment advisors that exercise investment discretion over 100 million or more in Section 13F securities. And you can get a list of those 13F securities from the SEC's website, but they generally include equity securities that trade on an exchange, certain equity options and warrants, shares of closed-ended investment companies, and certain convertible debt securities. Finally, from the Exchange Act, we have the Large Trader Reporting Form 13H. That's for advisors that exercise investment discretion over one or more accounts through which transactions in U.S. national market system securities are effected through one or more broker-dealers in amounts that, in the aggregate, amount to either, and here are the important threshold numbers, 2 million shares with a market value of 20 million, or with a market value of 20 million during a calendar day, or 20 million shares, or shares with a fair market value of 200 million during a calendar month. And so that's your 13H, and the 13H form is really just a list of the brokers that you use and some identifying information about the firm and the funds that are trading, the vehicles that are trading. Your Form D filing, that's to make use of the private fund exemption under Regulation D. So that really is what allows you to run a private fund, run a hedge fund or private equity fund, and instead of it being a mutual fund, which requires a lot more, has a lot more requirements from a regulatory standpoint. And so a Form D filing, just so you know, there is a prohibition on general solicitation for any funds that rely on Form D as an exemption from registration. And going back to what Derek was saying about marketing, this is what prevents, you know, having a billboard with a private fund's name on it. You know, it prevents generally advertising to the public. So I'll move on from U.S. filing obligations to talk a little bit about some regulatory updates. So first thing to note, back to sort of what I said during the first slide before we talked about regulatory reporting obligations, the SEC has broad authority to go and really check up on its registrants, including ERAs. Although I will say that they look at fewer ERAs than they do fully registered advisors. However, they still retain the right to go in and examine the books and records of ERAs as well. So the SEC's Office of Compliance Inspections and Examinations is the group within the SEC that performs the examinations. They've increased their investment advisor examination staff every year for the last 3 years at least. with the goal of increasing the percentage of investment advisors being examined. OCIE continues to use risk-based exams, and I'll stop right there and say a risk-based exam basically means that they look at the information that you report on your ADV and basically assign it a risk value. We're not exactly sure what goes into these risk determinations. The SEC does not make that public. However, you can imagine that switching a chief compliance officer with some frequency, complexity of structure, investing in riskier assets, using leverage, that type of thing might make a fund advisor more risky than another one. And then they take all that information and then they decide which firms to examine and which firms to maybe put down later on the list. They also use data analytics to focus and streamline their efforts. And included in the data analytics is the National Exam Analytics tool, where basically they look at the portfolio holdings in the trading of different products, of different funds, and they compare that to maybe events that have happened, earnings announcements, major movements of senior staff members, that type of thing. They'll look at that and they'll use that tool to help them seek out instances of potential insider trading or other types of inappropriate trading. So that's sort of how they approach examinations. As I said before, the likelihood of an ERA examination is lower than that of a registered advisor, but there's been an increase in resources, and that indicates that may change. And also, the SEC has never come out and said, the likelihood of an ERA examination is lower. We just know that sort of from empirical evidence. So they still reserve the right to go and actually examine an ERA as well. Here's some statistics for you. You can see the increase in the number of examinations. For 2015, 10%, for 2016, 11%, and for 2017, 12% of advisors were examined. There are a number of examinations that identify or result in deficiencies, and the SEC would indicate this by giving you a deficiency letter at the end of the exam. They range anywhere from 75 to just over 80%. I think this number, from my personal experience, is a little higher. I think that these numbers seem a little low to me. Almost every exam I have seen end in a deficiency letter, even if those deficiencies are quite minor.
Just on that, I mean, one of the things, the topical issues, is obviously there's a new head of the SEC. There's been some changes. Apparently, the person used to be a legal defender for some of the big banks, and is sort of married to an investment banker. It sounds like a plot for a popular TV show, but maybe that type of a person knows where all the evidence lies and will be a good actor in helping the SEC find where they need to find all the deficiencies, essentially. But I suppose at this stage there isn't or is there an idea of where the SEC might go under his direction?
Yeah, I think you're right that they could use their power for good, and know where everything's buried and be able to seek out those types of issues and find them more quickly than someone who was less experienced and had less of a inside knowledge of how these defenses are set up. However, based on what Donald Trump has said about rolling back regulations, getting rid of Dodd-Frank, I think that is very unlikely, and I think in all likelihood we will see an individual take that seat as head of the SEC who is pro these banks and pro advisors and anti-regulation. However, all that being said, it's all conjecture because that remains to be seen. We haven't really seen any changes with the SEC yet. And I think that, I'm going to withhold official comment because, it seems like anything could happen. So for now, we can look at, some of the statistics that we've gotten over the last several years. And I know that we can guess based on some statements that Donald Trump has made, what direction regulation is going. But I think that there's a lot unknown right now.
Yeah, no, that's true. I mean, this is another year of unknown unknowns. But, you know, I think in terms of how they operate on a day-to-day basis, it's unlikely that there'll be a significant change in day-to-day activities until there's been some changes to resources. So, you know, evidence of what they've been looking at before will still be relevant in terms of what they'll be looking at in the future, because they're a government organization and you can't turn a government organization around the corner very quickly.
That's true.
And with that, so I suppose moving on to their focus.
Yes. So some recent SEC areas of focus, you know, who knows what will change, but a big area will be conflicts of interest. So anytime an investment advisor's interests conflict or contrast with an investor's interest. And they've identified a few particular areas. Some of them they've identified explicitly to us. The SEC comes out with, you know, areas of focus every year, and we can look to those. And then we also sort of know, based on guidance they put out throughout the year, what examinations are focused on, what topics enforcement actions are focused on. So this is sort of a collection of all that. Expense allocations are a major one. You know, if you have expenses coming into the firm, are they properly belonging to the investor, or do they properly belong to the investment advisor? That information is contained in whatever disclosure language you've given to the investor. Anything you've told them, you know, that you will charge to them, you could charge to them, but anything that you haven't, or if there's ambiguity, then that could be a potential issue. SEC, as I said, wants to see some clear written policies. Another thing a lot of firms are doing is that they're going through and doing periodic testing. Particularly in the private equity area, there's been a lot of focus on how firms are disclosing the type of expenses that they charge to investors, and there's been a lot of interest in getting very specific about that. Some broad categorization of expenses really no longer is the norm. So again, advisors should ensure that disclosure to clients is accurate and detailed. Allocation of investment opportunities is another important area for the SEC. Some common deficiencies we see is just a lack of policies altogether. And I think that the SEC mostly is looking for preferential treatment of more profitable accounts. So if one account charges a higher fund, charges a higher fee than another, and then you see limited investment opportunities being allocated to that account or fund, then I think the SEC notices has an issue with that. There has been some recent cases where an individual, you know, partner of an investment advisor had his own private account, and extremely profitable trades were allocated to that account and not to the account with outside investors, and he faced enforcement action due to that behavior.
Sorry, I jumped ahead. I might have jumped ahead there in the slides.
Okay.
We're just conscious of time. I think some of these areas of focus, such as outside activities, personal trading, and valuations, are good identifications of what you know the SEC is looking at, and you've had a lot of experience in terms of these areas. So we'll just run through those quickly. I just wanted to come on to the whistleblowing section and follow up with cybersecurity, and if we can get through those, then we do have some questions coming in, so we'd like to get to them so we can move it on a little bit faster.
Okay, great. Yeah, whistleblower is a lot more interesting than conflict of interest anyway, so happy to move on. The SEC has been focusing a lot on the whistleblower role. Basically, that's allowing that any individuals who work within the firm to alert the SEC if they see any issues within the firm. And they've been specifically focused on making sure that any agreements, including non-disclosure agreements or severance agreements, allow an exception for employees to speak with the SEC. And recently, in October, they issued a risk alert, basically saying what we already noted through examinations and enforcement actions.
Mm-hmm.
We can move on from whistleblower unless. Okay, so cybersecurity is another major issue for the SEC. They came out in 2014 with a risk alert to let us know that they were investigating trying to get a better understanding about the cybersecurity policies that are already in place at firms, and specifically noted this industry as one that is at high risk for potential vulnerabilities. There's usually not too many people that actually that work at an investment advisor, and typically they're handling large sums of money. And so they've said this was an issue. They went out and looked at what firms were doing, and then came back with another risk alert and announcement of another sweep that basically listed those focus areas: cybersecurity governance and risk assessment, access rights and controls, data loss prevention, vendor management, employee and vendor training, and incident response. And so part of what Recordkeeping is doing for our clients is we are helping them kind of wade through those cybersecurity recommendations from the SEC and helping create cybersecurity policy.
Yeah, certainly, and we've already, we're working heavily with our U.S. Clients, but we've also signed up a number of clients in Asia for the additional support services that has been provided by our newly joined expert, and we're certainly helping firms to navigate those issues. Move forward. The insider trading controls, I mean, you talked about it earlier. I think one of the big points there to highlight is this winners testing, and one thing that firms are doing is if you're being extremely successful in what you're trading, it's probably worth having a look at of what's going on. And then we've also highlighted a recent action by the U.S. court in freezing accounts relating to an allegation that an individual used third-party accounts in China and the U.S. The main comment here is they used data analytic investigative tools to determine who was behind the suspicious trading. We were talking about this earlier, and this sort of indicates that it's not only they're identifying the trading, but the analytic tools seem to have identified who was connected to the accounts that were trading. It also indicates they were potentially using analytic tools to get down to the nitty-gritty of who the individual was, and sort of indicates potential email snooping and all sorts of, weird and wonderful stuff that you'd expect to see more on a television show than what's actually happening. So I think that's definitely an area to spot. You mentioned also earlier that there isn't a replica tool that firms can use to replicate what the SEC are doing. Is that correct?
Yeah, that is correct. Yeah. That's the NEAT tool, the National Exam Analytics tool that the SEC is using to look at what firms are actually doing.
So then, just moving on to some of the more significant actions in 2016, could you just go through some of those so people can understand what's been going on, basically?
Yeah, sure. So there were 868 enforcement actions in 2016, and that's up from 807 in 2015. A case will go to enforcement if, when during the examination, the SEC finds something that would constitute a violation of the regulations. Some major issues are FCPA-related actions, which is the Foreign Corrupt Practices Act, and whistleblower awards were at an all-time high in a single year. So some of the interesting ones, I mean, they're all pretty useful to look into. The first two are related to insider trading, and I want to say I won't go into the specific details about each one, but they're pretty, standard. Insider gives information to other individual who trades on the information and profits off of it. In the second bullet point there, that's the one where Phil Mickelson was involved as an unwilling participant in the scheme. But one thing that was a commonality between those two is both individuals who were named in these suits tried to cover up their activity afterwards. So that's something that the SEC is extremely sensitive to, and if there is any effort to sort of fabricate a story or make something up after they have found potential insider trading, then I do think that can make the issue that much more egregious. The next one, I'll skip over, is more specifically related to banks. They were using cash reserves that should have been held in a reserve account to actually trade for the organization. So there was a conflict of interest issue. JP Morgan in the next one was giving preferential treatment to some products that they created and therefore were getting the fees for, and would invest clients' money in those products. which may be riskier or higher fees than some other products that might have been more appropriate. And the big issue with that is that they did it without disclosing that they were doing that to investors. And finally, we haven't talked a lot about FCPA, but one FCPA case that came up, which was pretty highly publicized, is this OCIE. Daniel Ock in particular was named, and they, through various means were bribing officials in Africa, and have faced FCPA charges because of it.
Thanks for that. Now moving on to the questions. We have had a number of questions come through in that last few sections. Some of them are quite detailed and we might have to get back to you individually, but we'll see if we can bring them up. I think there's a question there on 13F. It says, I believe 13F are not counted in the 100, sorry, I believe swaps are not counted in the 100 million, is that correct? I.e. swaps with exposure to 13F securities are not counted. Have you come across that before, Alex?
Yeah. So I believe that swaps and other derivatives, if these transactions result in an investment advisor exercising investment discretion over the underlying traded U.S. security, that equity security, that would count towards your 13F securities. But this is a pretty technical question, and in terms of what 13F securities are and are not. As I said, the SEC has a pretty detailed list of that on their website.
So you're saying they're not counted, or they generally not counted?
They are counted.
They are counted generally.
Yes.
Okay. Okay. That's good to know. That's great. We also had a couple of questions come in. Have there been any changes to marketing rules that have occurred recently?
Yes, marketing rules. So marketing rules really have not changed too much recently. Generally speaking, a lot of these marketing rules that we have come from, a series of no-action letters that were written in the 1980s. And so, not a lot has changed since then. However, there have been a couple new pieces of information and guidance. The first one is, as I said before, reliance on Reg D exemption would not allow you as an investment advisor to generally solicit or generally advertise. Now, with the passage of the Jobs Act in 2013, there has been a change made to that where an investment advisor could actually take one of their private funds and rely on a different part of the exemption, which does allow general solicitation and does allow general advertising. However, the SEC has come out and said, we don't like this exemption, and if you do rely on it and start to generally advertise, we're going to be giving you a little bit of extra focus. And in response, most advisors have decided not to rely on that portion of the exemption and instead have continued to rely on the exemption that does not allow general solicitation. Another kind of piece of guidance that we've gotten on advertising recently is this concept of using social media to advertise. And the SEC has weighed in on that a couple of times. And in particular, the use of testimonials is not allowed, client testimonials in particular, and the SEC has said that this is also enforced when they look at social media sites. And I think that what's important to take from this is that the SEC is looking at your LinkedIn profile or your Facebook or whatever you're using as social media and counting it as part of your total advertising and applying these advertising and marketing rules to that social media profile.
So it's not necessarily banning it, but it's saying if you are using it, you still need to adhere to the requirements.
That's right.
Yeah. Okay. Also, we've had how responsive are the team at IARD in relation to resolving issues on the system?
Sorry, I muted myself there. I've had very good luck with them. I think that when I call and I have a technical issue, they're able to resolve it within a day. So if you do have any issues, please feel free to call them, and I found them very helpful. I will say though, the ADV is due on the last day of March, on March 30th, and I would not, I would not expect as quick of a response time during the time that everyone is sort of overloading the system trying to get their ADVs submitted. So the further away from the end of March you can call the SEC, the better.
Okay. Is there any danger with doing more than is required under the ERA status?
So I think that this is a tricky question to answer. So I think that the SEC is always looking for best practices. So sometimes, even though it's not written specifically in the regulation, there's an expectation that firms will be wanting to go above and beyond in certain areas. However, that being said, if you write that down as part of your policies, the SEC will hold you to that. So if you have something written down as part of your written policies and procedures, and it goes above and beyond what's required of an ERA, and then you're not doing it, it's just written down, but the firm's not actually practicing it, a defense can't be, well, it's not actually required of me. Once it's in your compliance manual or your compliance policies, then the SEC does hold you to it. So as I said, it's a careful balance to strike, and I think that's part of how we help our clients is helping them know what standard practice is, what do we see on the market, how firms are responding to regulatory requirements, and then finding that right spot to be where you're not just doing the bare minimum, but you're also not holding yourself to a higher standard than you need to and invite potential for failure.
Sure, that's great. Now, I think we have a couple of additional questions, but they're actually very, very technical in nature, and I think we'll go back directly to the individuals on those. I don't know whether you can, yeah, they just seem to be very specific, so we'll pick up on those as such. We've come to the end of our hour. We'd like to thank everyone for joining us. If anyone has any additional specific questions, please do feel free to contact us and ask us about any of the issues that we've discussed today. Cordium in Asia is hoping to have a number of additional webinars this year covering topics such as the Fund Manager Code of Conduct, risk assessments, the change maybe or the focus of looking at risk assessment and risk management as a way to satisfy your compliance requirements. I'm sure we'll be following up on our cybersecurity products and what we can deliver to firms. But with that, I'd like to thank Alex. There was no questions that we needed Winnie to participate in today, but generally we're all here to provide support from different angles. So I'd like to thank her for attending, Alex for attending, and I'd like to wish everyone a wonderful day.
All right, thank you.